and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Welcome back to the Unpacking the Case podcast. In this episode, we're answering questions that came out of our latest commercial property webinar. With over 4,000 registrants, there are a lot of questions, and that probably tells you everything you need to know about how much uncertainty there is in the market at the moment. So what we've done is pull together the themes that kept coming up and use this episode to work through them properly. We'll be talking about the proposed changes to rent reviews, particularly the debate around upwards only clauses and how that might play out. We'll also look at security of tenure under the Landlord and Tenant Act 1954, development breaks and some of the more technical but critical points around things like notices and tenancy status. Alongside that, we'll touch on some of the recent cases that our audience are asking about. Let's get into it. Hi, Richard.
Hello, Lizzie, and how are you? What have you been up to lately?
I'm very well, thank you. I have been busy, but never too busy to record a podcast with you.
That's true. Mm-hmm.
So we did a webinar a few weeks ago now on, it was a commercial property update webinar, and it was extremely popular. We had our highest numbers to date, but as a result, we also had loads of questions that we didn't get a chance to answer. So we're here to answer them now.
4,600 people. Mm-hmm.
How many was that, sorry?
4,600.
4,600, yeah. So no shortage of questions. Should we make a start? The first load of questions were all to do with rent reviews and the proposed upwards only ban, which is obviously very topical. So question one, will rents increase in line with RPI, CPI be affected?
Yeah, I mean, the answer is yes. The upward and downward rent review provisions in the English Devolution and Community Empowerment Bill basically say that if there's a rent increase, there can be a rent increase and you don't know in advance what the rent increase is going to be, then it'll be subject to the upward and downward rent review, and that will include retail prices index and consumer prices index, yeah. Turnover rents as well.
Do you expect a shift to stepped rents or index-linked reviews instead of traditional reviews?
I'll leave that to the surveyors and the valuers, but I think that, well, fixed increases, stepped rents and fixed increases that you know in advance won't come within the ban. So they might sort of at least partially be based on stepped rents. As to RPI, that will come within the ban, as I mentioned, but if you look over a period of time, it's more likely than not that, well, RPI will have a rent increase. RPI doesn't fall systematically year after year after year. So possibly. I think there's another way of avoiding a large number of properties, the consequences, and that's have shorter leases without rent review is the most obvious thing. Not always obvious.
So should landlords stop including upwards only wording into heads of terms now?
No, it's not going to be retrospective with one provision, and that's the options to renew, including rent review, which was introduced into the House of Lords by the government. So no, I wouldn't do anything yet. It's not going to be until 2028, I would imagine, until something actually happens.
Okay, and there's a couple of questions about when the ban applies. So does the ban apply to lease extensions or supplemental deeds?
Well, a lease extension is a brand new lease, and if it's a brand new lease, then it's going to post whatever the implementation date is. Then it's going to sort of kick in. It's a surrender and a regrant, or surrender and grant of a new lease, to be precise. Mm-hmm.
And what about agreements for lease entered into before implementation?
That's specifically excluded if you've got a contract before the legislation is entered into. You've got to point out that none of this is, passed fully through Parliament yet. It might be subject to amendments and regulations and the likes, but as it stands at the moment, a pre-commencement agreement for lease won't kick in the upward and downward review.
And finally, what about options to renew exercised post-implementation?
Well, that was the thing that was introduced by the government into the House of Lords on March the 17th, and basically says if you've got a March the 17th onwards option to renew with a rent review, then as it stands at the moment, it hasn't been scrutinised particularly yet, but that will be come within the legislation.
Next question is asking, will landlords be forced to vary existing leases?
No, not at all. It's not going to be retrospective. They'd have whole kinds of human rights claims on their hands. I suspect they might know that.
My favourite topic, collars and caps and collars. What happens to long leases with RPI, CPI caps and collars post 2030?
I don't know if you want to answer this one, Lizzie, because this is your forte. But you should never have told me, what a rent collar is.
I know, and all I knew was the word. I don't actually know what it means.
What they're alluding to is the fact that by February 2030, the government is saying that they're going to get rid of RPI as a means of calculating various things, an official means, to be replaced by consumer price index and housing, which will reduce the kind of percentage, if you like. All it does, it doesn't get rid of RPI. It just basically, it's a different way of calculating RPI, which is going to be more beneficial to tenants in the context of rent review, at least if based on RPI. So no, in terms of caps and collars, the government were saying initially that they might introduce separate regulations, which in some circumstances allow rent collars if there's a corresponding rent cap, a maximum and a minimum rent. So yeah, but no doubt you'll have a look at that for me and let me know when it comes in.
Can index-linked reviews still be used in new leases?
Yeah, there's nothing stopping them. I say there's a lot of myths about what's going to happen, or supposedly going to happen in 2030. It's not that it disappears as a form of index linking. It's just that the method of calculating will be based on CPIH, Consumer Prices Index and Housing.
And why shouldn't rents fall if the market doesn't support them?
I think landlords need a guaranteed cash flow. That's the argument. I can see the argument against that. I think my main concern is what I mentioned in the actual course itself, that the avowed intention of the legislation is to help the high street retail sector. If rents reduce, then why shouldn't you have the markets going downwards? Why shouldn't you have a rent review that goes downwards with it? Most high street, the vast majority of high street retail is 3 or 5 year leases. They wouldn't have rent reviews. And I think in the future, if you want to avoid that, that's the obvious reason. If it's a kind of lease, tenants want in the high street, they want 3 or 5 year leases because they don't want to be bound. They want flexibility, have done for many a year, even more so post-COVID.
Thank you. Does the legislation apply to excluded leases?
Yes, it does. As long as you come within section 23 and the definition, which has been amended so you don't need to be in occupation. Yeah, it applies to 54 Act excluded leases.
If a tenant exercises a renewal option in a pre-reform lease, do the new rules apply?
I think we've mentioned that before. This was this amendment which was introduced into the House of Lords on March the 17th, which basically says if you've got an option to renew in a lease, that's the one situation that will be retrospective if the option to renew includes a rent review. But we'll have to see with that. So it was a government amendment, so it'll almost certainly, I suspect, get through.
Next question. Can a tenant renew only part of the holding?
This is sort of not about upward and downward rent reviews, I'm assuming. Basically, you can agree whatever you like on a 54 Act renewal, but in the absence of agreement, Section 32 of the Act says that the tenant's entitled to the holding held by themselves at the time of the court hearing, and the landlord can, at their behest, require them to take on sort of greater part. The holding is basically the part that possession of at the time of any court hearing. There's a case about it, 2024, Sainsbury's supermarkets and Medley assets, if you want to have a look at it.
Can a landlord insist on a development break where works don't require possession?
If the landlord can basically, if they reserve the right to kind of enter the premises to carry out additions, alterations and improvements, then as long as they are not breaching quiet enjoyment, they should be able to, just use the clause in the lease if it doesn't require possession, which allows them to go in. If they are going to carry out substantial works, so the tenant basically can't do their work, it's just one of the things in the Spirit Pub Company case that we Pridewell properties that we looked at. If it's substantial, so the tenant can't really carry out their works, if you like, or their profession, then no.
So moving on to redevelopment. If a redevelopment break is exercised, must the landlord actually redevelop, or is it just a tactic to remove tenants?
If the landlord is making misleading statements or representations, they could be sued for any loss under Section 55 of under Section 37A of the Act, which used to be a separate, different version, Section 55 it used to be. And they would, we got a case that I don't think I went through, McDonald's and Shiriyama Shukusan, which is all about that. You could use the development break ground potentially, and then find, it's whether you've got a real chance or a real prospect, a reasonable prospect, would a person of business take the risk? And it's not impossible that the landlord successfully used, sort of the intention to develop ground F, but then found for whatever reason they couldn't go ahead with the development.
I guess this is a similar question. Can redevelopment be used strategically even where works are not strictly required?
The answer is no. That was settled by the Supreme Court at the end of 2018, and S. Francis and Cavendish Hotel said there's a but-for test. But for the fact that the tenant's still in occupation, would you still want to do the work? So in S. Francis, they carried out they were intending, they said, the landlords, to carry out various works, including, which weren't really needed just to get rid of the tenant, including knocking down a dividing wall and rebuilding it in exactly the same place with exactly the same materials. And they failed in that case. S. Francis, St. James Art Gallery, and the private shop. You have a private shop where they were selling fancy tapestries in rugs. You can probably see some.
Sounds like your kind of shop, Richard.
Yeah, I often go there sometimes you wake up in the morning, Lizzie, and you think, I need a fancy tapestry. And I'm off to German Street in London and parading my fancy tapestry out of the station back home.
Moving on to talk about reversion releases. Does the Park Cakes case affect whether reversion releases fall within the Act?
Well, this is another one of your expertise, Lizzie, because
Colin the Caterpillar Cakes.
Park Cakes produced Colin the Caterpillar Cakes for Marks and Spencer's. Yeah, I mean, the reversion release, I'm presuming they're talking about the Landlord and Tenant Act 1954 as opposed to the upward and downward reviews, which isn't an act yet anyway. But yeah, reversion releases are different from agreements for lease. Section 28 deals with agreements for leases. An agreement for lease is something which you've got a contract to create a lease in the future, and that's what Section 28 basically applies to. A reversionary lease, you're granted the lease now, it's just that you can't go into possession until a future date. And that's the real difference. Reversionary leases, you can't have a lease that comes into possession more than 21 years in the future under Section 149, subsection 3 of the Law of Property Act 1925. I remember that from my university law lecturing days.
Excellent. So moving on to a few questions about tenancy status. So the first one being, when does a tenancy at will become a periodic tenancy?
It sounds like a joke. I don't know. When does a tenancy at will become a periodic tenancy, Lizzie? But the answer is we used to think we knew, but we don't because of some various cases of late, including one of the AP wireless non-tower cases, and so one or two of the older cases involving NHS property services. They basically, if you'd have asked me in the past, if there's no negotiations going on and you've got a tenancy at will, if you then start paying the rent and the landlord accepts it, I would have said certainly when a pattern emerges, there's a periodic tenancy which can be within the 54 Act, whereas tenancy at will can't be. But it's been fudged a bit by some of the recent cases. If I was a landlord or tenant, I would assume that if I start collecting rent, and especially if there's no negotiations for a lease or a new lease going on, then I'd assume it might become a periodic tenancy and I'd get the 54 Act excluded. What's my motto, Lizzie?
If in doubt, contract out.
That's it. My catchphrase.
As seen in the Estates Gazette.
Yeah, apparently.
Next question is, should landlords always document tenancies at will to avoid risk?
Yeah, in spite of the cases, some of the cases I mentioned are ways of getting people off the hook when they've already made the mistake. It's best not to make the mistake. If you're going to create a tenancy at will, create it expressly. In spite of the cases, which have said you can have 15 years of tenancy at will, I would keep it short whilst you negotiate the final lease. And in spite of the cases, including Court of Appeal cases, if you're negotiating, I'd still be reluctant to accept rent in advance. I think we've answered the next question.
If no term is specified, but there is rent and exclusive possession, is it a lease?
There's got to be a fixed maximum duration for it to be a lease, and that's what the other AP Wireless and On Tower case was all about. But if you've got exclusive possession for a term at a rent, then it's a lease unless there's an exceptional circumstance. It's House of Lords in 1985, Street in Mountford, that if you've got exclusive possession for a term at a rent, I'd assume a lease. But if there's no specific term, then you've got an issue. If it's a periodic tenancy, the idea is that you know from the beginning what notice to terminate that particular period, and so that's valid. The exceptions are things like caretakers, service occupiers for the best performance of the job. And we did a few cases on guardianship schemes, people who basically sort of live in properties that are pending, them being demolished or being sort of rebuilt or whatever, to stop trespassers getting in. No licenses generally, even if there's exclusive possession for a term.
So there were quite a few cases that you covered during the webinar. One of them was AP Wireless 2 and On Tower UK Limited. Should this case have created a periodic tenancy?
The Court of Appeal said not. There was no fixed maximum duration in AP Wireless because it was for a minimum term of 10 years and then no earlier than the end of 10 years. Either side could give 12 months notice, and I can understand how they could say that that's no fixed maximum duration, so it wasn't a lease. Whether it depends on the fact it's sort of specific to communications, equipment and the likes is another matter. But they talked about but ignored the standard Supreme Court House of Lords case from 1992 of Prudential, the London residuary body, which is the council, the original GLC, and their successors could only get possession when the land was wanted for road widening, and that was no fixed maximum duration, but it wasn't a lease. But they were paying the rent yearly, and it was decided that was a periodic tenancy. But they just seem to have ignored that and preferred a case which was only Obiter decision called Beresford and Mexfield Housing. But bad decision.
Does a rolling break clause undermine a fixed term?
No, it's got to be a fixed maximum duration. So a break clause is, what the maximum duration is. It's just that you can break it early, just like you could effect forfeiture early, or have a notice to quit early or whatever. Surrender.
Another case you looked at was Lamba and Enfield. What do you think practitioners should be cautious relying on this case?
I can't see that Lamba and Enfield's correct. It was between Section 196 of the Law Property Act and Section 23 of the Landlord and Tenant Act. And Section 23, well, the courts have decided that if you use Section 23, notice, then even if it's returned the moment that, if you've used recorded special delivery, the moment it's posted, it's deemed to be served. Whereas Section 196 expressly says if it's returned, it's not served. But nevertheless, in Lamba, where they'd said that, you shall use Section 196, they decided by implication you can't use Section 23. I think a lot of people think it's wrong. Just in case it's right, I think, look at the words of the lease, and if it does say shall use Section 196, then I'd use, basically, what you could do is sort of just deliver it personally, pin it to the front door. It goes against the Court of Appeal case called Blunden and Frogmore, as far as I can see.
So another case was White and Older. Does this case extend to boundary obligations?
It was all about informal boundary agreements, was White and Older. And actually, we did a podcast on this when it was new last summer. And it goes back, principles that go back as far as, I think it was 1750, Penn and Lord Baltimore and the Mason-Dixon line in America when there was still a colony. But an informal boundary agreement can be binding even though the purchasers don't know about it, which is why the CPSE inquiries were changed last autumn. But it's not boundary obligations. That's more to do with who actually has the obligation to maintain the boundary feature. There was a case a few years back called Lanphier and Chandler, which basically said T-marks on your plan don't necessarily tell you who that owns the boundary feature. It just tells you who's bound to maintain it. So not really, no. There was a case called, I think it was Seckert and Derwent, Court of Appeal case, which did say that T-marks were strong sort of evidence of who owns the boundary feature. But White and Order is about boundary agreements.
And the Bridgend CBC case, what determined liability timing in that case?
It's the Japanese knotweed liability, where Mr. Davis purchased his property in Bridgend in 2004 when there was already Japanese knotweed, not on the land, but on a cycle path owned by the council behind his wall. The Royal Institution of Chartered Surveyors produced reports about Japanese knotweed's dangers in 2012, and the council should have, they said, done something about it by 2013. And they didn't until 2018, but because he'd already bought subject to, there'd already been Japanese knotweed on the other side of his wall, there was no liability of the council. Actually, in 2020, and they've reiterated it since, Rick said that Japanese knotweed only in exceptional circumstances will it cause any kind of structural damage. It's not as dangerous as buddleia next to your house, apparently. And of course, the next big one is going to be bamboo. That's the next one. And various other prohibited substances. Prohibited plant, curly waterweed, that's illegal to cause it to be propagated in the wild. And duck potato, Lizzie. A potato, half duck, half potato.
Yeah. Things to look out for.
It's been genetically engineered for Sunday lunch. No, it hasn't.
Moving on to service charges, does consultation, Section 20, apply to long leaseholders who sublet?
Yeah, Landlord and Tenant Act 1985, Section 20. It's that Cloisters case. Cloisters business, whatever management company, and Vari, which said that mixed-use premises might come within the provisions whereby you have to go through service charge consultation and the likes. It's if there's a sublease, I think Section 36 with minor definitions in the 85 Act says it will apply both the tenant and the subtenant will have the rights, and the landlord, head landlord, and the intermediate will have the obligations. So yeah.
So, final question around binding agreements. Is an email disclaimer enough to avoid a binding contract?
Yeah, well, these are the cases that said the emails can give rise to contracts in land under Section 2 of the Law of Property Miscellaneous Provisions Act, and be in writing and signed and contain all the express terms in one document, or comply with Section 53 and transfer beneficial interests in the land. For the contract point, for Section 2, you should make it clear it's subject to contract. And otherwise, I mean, one of the cases, Hudson and Hathaway, there was a residential family breakdown case, but he just he's finished his email by saying kind regards Lee. His name was Lee Hudson, that was his signature. That caused him to transfer half the beneficial interest in his house. I think you make clear in your emails that nothing in this email constitutes a legally binding agreement, and also make sure that you never email somebody saying you can have my house, kind regards Richard, because that'd be fatal. And I think that's it, isn't it, Lizzie?
That's all of them. Thank you, Richard.
My pleasure as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.